Understanding living wills and advance directives. In 1983, 25-year-old Nancy Cruzan, as a result of an auto accident, awoke from a coma in a persistent vegetative state. After 4 years awaiting a recovery, Cruzan's family sought to remove her feeding tube. After 3 years of court wrangling, the Cruzan family finally convinced a judge that Nancy would not have wanted to live on artificial life support and received permission to have Nancy's feeding tube removed. In 1990, 26-year-old Terry Schiavo collapsed in her home. After 10 weeks in a coma, Schiavo awoke in a persistent vegetative state. In 1998, Schiavo's husband sought to remove her feeding tube. What ensued was a 7-year court struggle pitting Schiavo's husband against her parents in a battle over whether to continue artificial life support. One of the common themes of these two women was that neither Cruzan nor Schiavo had advanced directives expressing their wishes regarding artificial life support or other life-sustaining medical care. Both cases involved families going to court and asking judges to interpret what the incapacitated person's wishes were. In the Schiavo case, the court battle featured an extremely bitter struggle between Terry's husband and her parents. An advance directive notifies your caregivers what kind of treatment you would like to have if you lose the ability to make medical decisions. For instance, if you become comatose or were in a persistent vegetative state. Many hospitals discuss advance directives with their patients at the time of the patient's admission. There are two common types of advance directives. The durable power of attorney for healthcare allows you to name an attorney-in-fact for healthcare decisions, also called a proxy or advocate, who will make decisions on your behalf regarding what treatment you do or do not want. The other advance directive, the living will, contains a set of instructions to healthcare providers to be followed in the event that you cannot communicate your wishes for yourself. A living will usually sets out specific directions as to the course of treatment that your caregivers should take, or, perhaps most importantly, sets out the treatments you wish to forbid your caregivers to undertake. These instructions are to be followed if you are unable to give informed consent due to incapacity. A living will is an important tool for both your peace of mind and that of your family. With a living will, both your family and your doctors know what your wishes are. It can save you from subsisting in a state that you would never want to be in, and it can save your loved ones the painful burden of making end-of-life decisions on your behalf.